Thank you for coming to our panel discussion on hate speech called Sticks and Stones, the Power of Words, What Can Be Said, and What is Really Prohibited. The format for today is I'm going to introduce our panelists, and each of them will give sort of a brief opening statement, and then we want to open it up to Q&A from all of you. I will have a microphone for the Q&A so I can come around and take your questions. So today we are joined by Professor Jeffrey Jackson. He's a professor of law and the director of the Washburn School of Law Center for Excellence and Advocacy. Also Marc, who is on the executive staff at Washburn and serves as the Washburn University Counsel. And then also Lauren Bonds, director of the American Civil Liberties Union, Kansas. So thank you all for joining us, and I will turn it over to you.
All right, thanks everybody. I have to remember to hold it like this. All right, we're good. So I'm Jeff Jackson. I am a professor of, among other things, constitutional law across the street here at the Washburn University School of Law. And so my job on this panel is kind of to give you the background on the idea of the First Amendment, the Constitution, and how all that relates to hate speech. And I guess the first big thing that I'm going to say here is, in terms of the Constitution and hate speech, there is no such thing. And what I mean by no such thing, I mean there is no such concept of hate speech as a form of speech in the First Amendment. Basically, the First Amendment has some doctrines, and some of those doctrines deal with speech that we might think of as hate speech, but it's really a different sort of thing. And the strong First Amendment that we've got makes regulating hate speech somewhat problematic. When you think about how the Constitution handles speech, we're talking about two different things, and the two different things are, one, what is that particular type of speech, and two, what about the place that what about the venue in which that speech is taking place? Now, generally speaking, there is nothing that a government can do in a traditional public forum, that is, a traditional place that's generally open for free speech, right, to regulate this idea of hate speech that is directed just generally at a group of people, or using words that may degrade a certain group of people. There are some limits to that, right? So the first one of those is what's known as the true threat kind of thing. So if you're just generally standing on a street corner, or say on the lawn at the Capitol, and you're railing against some group, well, it's not something the government can prevent you from doing. If, however, you actually communicate a true threat, and a true threat is toward a specific person or group, where you're saying, I'm going to go shoot some people, I'm going to go burn something down, well then you can be arrested for disturbing the peace. True threats are one kind of idea. The second kind of constitutional idea that the government can regulate are what are known as fighting words. And fighting words are very simply words that, if said to a person, would cause a reasonable person to punch you in the nose. That's really kind of the test, actually. But it's that might cause a breach of the peace. Now, the problem with the fighting words doctrine, because a lot of people say, well, doesn't that apply to hate speech? Well, the problem with the fighting words doctrine is that it's a very specific doctrine. That is, it doesn't apply to you just generally talking about a certain group. That is, it's got to actually be words directed at a specific person, and a specific person right there with you. Right? So it has, the idea here is, between true threat and fighting words, you can get some of what I think people think about when they talk about hate speech, but not nearly all of what people might consider hate speech. And then the third big doctrine is this idea of, you've got the fighting words, you've got the true threat, and then you've got the incitement to violence, right? And the incitement to violence is when you're, again, basically saying, let's go burn something down, or let's go do this. And again, people think, well, isn't all hate speech inciting violence? Well, yeah, in the larger sense, yes, but not in the constitutional sense. Because in the constitutional sense, the incitement to violence has to be something immediate. And it has to be you not saying hyperbolically, sometime we need to go do something. It's got to be something immediate. It's got to be you personally inciting immediate and imminent violence. We learned that from a case called Brandenburg, which is one of my favorites to teach, only because that was members of the KKK talking about, we might have to take some revengeance. And I say, well, yeah, they can be arrested for butchering the English language, but it's just one of those things that's just kind of a nebulous threat doesn't qualify. So that's kind of, outside of those things, what can the government do? Well, in a regular public space, right, someplace where we expect citizens to utilize their First Amendment rights, the answer is not much more. The government can do what are known as content-neutral time, place, and manner restrictions. What that means is, so long as what they're not trying to do is get at the content of the speech, that is, they're not saying, well, you can do this if you're in favor of this side, but not if you're in favor of that side. Right? As long as they're not trying to get at the content, they can do time, place, and manner. They can restrict maybe the times in which you say something. That is, if you think about, say, the State House grounds, right? You can't protest on the State House grounds after 10 o'clock because people in the area might be trying to sleep, or there are no lights in the area and you might fall down and get dangerous, so they can restrict the time. They can restrict the place. That is, on the State House grounds, you can do what you want, but maybe you can't talk right outside a legislator's office because then you're disturbing them while they're doing the work. And they can even restrict the manner. That is, as we've seen just recently, you can't unfurl banners in the State House or things happen, right? They can say, and really the touchstone there is those restrictions have to be reasonable for the time and place, and they can't be focused at content. So if what you're trying to do is outlaw hate speech, that's a problem, right? Because it has to be content neutral. You can't do those sorts of things. Now, how does that apply to, say, a college campus? Because that's one of the things that we're here doing. And the answer is, it's not exactly clear. The Supreme Court has not been terribly good about giving us a lot of guidance. Lower courts have, but the lines that they have drawn are sort of fuzzy. The Eighth Circuit Court of Appeals determined actually that the idea is that if you're on the grounds of a campus and you're outside at the very least, well, that is akin to what is known as a designated public forum, which means it's just as if you were protesting on the grounds of the State House or some other place. And really the only thing that the university can do is regulate the time, place, and manner. That is, they could say, hey, no protesting no protesting during a finals exam because you might disturb it, or no protesting, or don't talk outside the windows because of that, or we can't, if you're gonna talk or do something, it has to be below a certain volume because we're trying to study here, right? So, but beyond that, there's not a lot that they can actually do in the public spaces. Now, as you get away from the more public spaces, then yes, there's more stuff that the university can do, because if you're talking about, say, classrooms when not in session, and I would think like the hallways of a building, if you're in Morgan Hall, the university's got a little bit better ability to regulate, although you're still probably talking about mostly, is it reasonable, right? And if you're talking about in classrooms and stuff, they still can't censor you according to what you say. They can censor you in the manner in which you say it. They can say, for instance, probably, you can't use swear words when you're talking in the hallways of the university, right? So, but they can't say, the content is what we don't want. And then if you're talking about inside a classroom when class is in session, well then, so long as they don't as long as they don't make a distinction based on the viewpoint of the person talking, well then the university's free to do quite a bit more. That is, they can say, okay, the discussion here is going to be based solely on the content of the class, or we're going to talk, but everybody, this is a question that we're talking about and it's very controversial, so we're going to talk, but we insist that everybody talk in a very civil manner to each other. And they can do that inside a classroom so long as they aren't saying you can talk we're going to talk in a very civil manner, unless you're talking about this side of the argument, in which case you can say whatever you want, right? So as long as they're treating all viewpoints equally, then inside a classroom they can do that. And as I say, in the hallways, maybe a little more, but beyond that, there's really not a lot of guidance on what universities can and can't do, and the general presumption is that the First Amendment trumps, and that they can, in fact, not actually regulate the content of what you're saying. So there is no kind of category, I guess, at least in the First Amendment, that talks about speech that may be demeaning to a group, or may make a group feel uncomfortable. In the general scheme of things, so long as you're not fitting into those categories that I talked about, that is, you're not actually threatening someone, you're not harassing them, you're not insulting them to the point where it falls into the fighting words doctrine, then it's very hard for a governmental entity to regulate those things. The guidance isn't always clear, and there are so many situations that I think it's really hard for a university to, consistent with the First Amendment, regulate a lot of what we consider to be hate speech. And my argument actually is that's the way the First Amendment is designed, and we've said that. It's the idea that not only do we protect the speech that we like, it's that the First Amendment protects even the speech that we hate. But for college administrators, for universities trying to create policy, for university lawyers, it makes it tough.
Well, I think I'll give up my spot because that was the greatest line I could have. I'm Marc Freed, University Counsel. Can you hear me? The folks on either side of me have a lot more experience and expertise in these areas. So I'm not going to talk about the First Amendment specifically in hate speech. What I thought I'd do, kind of stealing the concept from one of Kevin Wilmot's movies where he took the idea, well, what would the United States look like if the Confederate States of America won the war? So although we can't have a rule against hate speech, what would it look like if we did? And so the first thing we'd have to do is we'd have to define it. Because since it's not a recognized category, there is no definition out there. So in thinking about it, I've been to, as a presentation in here a year ago, was at the town hall, have had people ask me questions. So I've kind of heard what people think they may want. So one of those things is, should hate speech include offensive speech? And what I've heard from a number of people around here is yes. So would our hate speech code then say you can't say things that offend other people? Secondly, we talk about if we're consistent with how our sexual harassment and other forms of harassment work, it's not that the person who said it intended to be hateful or offensive, it's how the person who heard it interpreted it. And that's just how it is. So if we did that, that means if a statement is made and someone is offended by that statement, then that would be considered a violation of the hate speech ban. The third thing is to talk about, normally when you talk about language in a harassment setting, at least in the law, normally words in and of themselves used one time aren't enough to be so severe or pervasive as to create a violation under the law. There has to be a series of events, unless the words maybe are like fighting words or threatening words. But again, the sense that I get is even one time using words that are so offensive or hateful that there are people who believe action should be taken just after one time. So if you think about if we have then one of those bans, then what would that look like under certain scenarios? And I'm just going to put the scenarios out there. I'm not going to take us through them. If you have questions about it, we can do that. But just things to think about. So scenario one, there is a person standing out on the plaza area on the east side of Memorial Union, and they're talking about the rights of the LGBTQ plus community and how they should be treated equally, and they should have rights of marriage and access to benefits as spouses do in employment cases, and be able to walk into cake stores and buy cakes for their weddings. And someone walks by and they have this sincerely held religious belief that people in the LGBTQ plus community are committing a sin. That's how they've been raised. That's their sincerely held religious belief. And so when they hear someone talk like that, it offends them. They even kind of consider it hateful because those people are challenging their very values. And so they file a complaint. Was the person speaking out in favor of LGBTQ plus rights, was that offensive in hate speech? Should action be taken? Example 2, to think about. 3 or 4 young black males are in the cafeteria at lunch, and they're just talking to each other. They're not bothering anyone else. They're getting along. It's a friendly conversation. They knew each other even before they came to Washburn. And in the process of their conversation, they use the N-word when they're talking amongst each other. That's just how they've always communicated. That's just been part of how they've done it. There's a group of students sitting nearby who are white, and they hear this. And the use of the term constantly over and over again is offensive to them. It makes them feel very uncomfortable, maybe even a little threatened. So they report that as a violation. Is that a violation? And I use that example specifically because I was told by someone who's worked here a lot longer than I have that that was actually a situation that occurred in the Stauffer Commons at Washburn University. So that's not that far from reality. So when you think about if we really do that, what speech can really be impacted? A speaker from the ACLU dinner a couple of years ago, Floyd Abrams, who wrote a white paper on the First Amendment, talked about, freedom of speech is designed to protect those who are not in power, to preserve the right that they may speak out what they want. Because generally people who are challenging the status quo and are seeking change, if they don't have the protections of the First Amendment to express their opinion, the people who are in the power are going to be offended because the people challenging the status quo are challenging their life, right, and the way they live. And so think about if we expand that discretion to governments to punish for offensive speech, who may be more likely punished if we really go that route? And is that what we're looking for? Thank you.
All right, thanks, Mark. And sorry, I talk with my hands a lot, so if I'm losing the mic there, just let me know. As Dr. Irby said, my name is Lauren Bonds. I am the legal director and the interim executive director at the ACLU of Kansas. And the ACLU as an organization has always had a really singular view of hate speech. And that's that it should be restricted as little as possible. And so that's really derived from Justice Brandeis's concurrence in this case called Whitney versus California. And so I won't butcher his eloquent writing by trying to quote it directly, but essentially he said that the remedy for hate speech or bad speech is more speech. So if you let good speech and bad speech get in the same space, the good speech is going to beat that out. It's going to remedy it, and that's how we have better ideas and better values as a society. I would say in recent years, at least since I started the ACLU, which is about 2 years ago, we've been more critically assessing whether that philosophy is the right philosophy. And not from a legal perspective. I don't think anyone in the ACLU would ever advocate there should be a hate speech exception to the First Amendment. But just more how it relates to other rights that we care about. So one of the reasons for that is Charlottesville. The ACLU played a very, unfortunately, prominent role in that incident, in that the ACLU of Virginia defended the Unite the Right rally in their application for a petition. So there's that. I think another reason is the ACLU is becoming more and more diverse as an organization. There are staff of color, there are LGBTQ plus attorneys. And so these people, I guess myself included, are kind of applying our lived experiences to this philosophy that more speech can remedy hate speech. And so I think a lot of us who belong to a minority community or grew up, in a marginalized group would probably say if we felt that we were the target of hate speech or slur in a government space, whether that's a public school or maybe public employment, that people telling this person who said a slur, said whatever, that they're wrong, whether that actually remedied the problem for us. So the question kind of being, did that make us feel more safe, more included, more welcome in that public space by just having other people tell them they're wrong? So there's that piece of it. And then finally, I would just say our organization is becoming more robust. And so as a consequence of that, we're working on more and more issues that directly conflict with the First Amendment. And so, we're doing immigration rights work, and we're doing racial justice work. And so more and more we're seeing those, values that we care about. We care about the First Amendment a lot. We care about immigrant rights a lot. We care about racial justice a lot. Those issues are really starting to butt up against each other, and we're really having to think more critically about, where the First Amendment falls within this hierarchy of other rights that are protected by the Constitution and federal statutes. And I think that's, something we have to grapple with kind of in the practice of law, at the ACLU, particularly at the state affiliate level, which is what I work at, where, you get complaints from virtually, literally both sides of disputes. And I think this happens a lot in the secondary school situation. So I can think of one day we got intakes from, parents on both sides of this issue at a high school. And so the parent of one child, the mother, she called in and she thought her son's First Amendment rights were being restricted because he was suspended for bringing a Confederate flag onto school campus when he was, told he shouldn't bring it on there. And we also got a call from the father of another student, the student who felt he was being bullied by the kid who brought the Confederate flag as a black student. And he was taking the position that he didn't think the school was going far enough to protect this kid. So that they should have done more to shut down that discrimination. One day of suspension was not sufficient. And so that was really a space where, we had the First Amendment and Title VI, which protects you against discrimination in a public school, really butting up against each other. I think that really goes to your point earlier about forums, right? Like a public school, a public secondary school is different than a college campus. It's a more limited forum, so more restrictions are applicable there. But that being said, I think there's a whole bunch of different categories of speech, that aren't quite hate speech maybe, if we were to figure out how we would want to define it, but also are discriminatory and might be problematic in a public setting. So I would just say that, this is something not only, schools are grappling with, that attorneys are grappling with, the courts really haven't figured out how to deal with this either. And so I'll just give a real quick example, and then I think it's probably time for questions. Okay, so The First Amendment protects speech in public schools for students. You don't shed your First Amendment rights at the schoolhouse gates. And there's only really 4 exceptions to a school district's ability to restrict speech. And so one of them is if it's reasonably likely to cause a disruption, if it's vulgar speech, if it's speech that promotes drug use, or if it's school-sponsored speech. But you can think of a lot of different types of speech that don't really fall within any of those exceptions. So, for example, a student wearing a shirt that says he thinks gay people are going to hell to a Gay Student Alliance event. And so that happened out in California. And the Ninth Circuit actually said that the school district did not violate his First Amendment rights by suspending him and making him take his shirt off. And I kind of struggle with that decision, even though, thinking through this, because I don't think it really falls within any of those categories. But they took the position that it was reasonably likely to cause a substantial disruption in the school. And they didn't take the position that it was going to cause a fight, that it'd be some kind of situation where a fight broke out or kids were going to get mad at each other and start threatening each other. They really applied Title IX to it. So they said, this is going to interfere with students' rights to learn. And it's going to create a hostile educational environment for them. And the school district, brought in all the statistics about bullying and its impacts on education. And that's really how they got there. And I think, courts are going to, in the secondary school space anyways, are going to continue to struggle with how to resonate those rights with each other. And I think, even civil libertarians like the ACLU are struggling with how we resonate those rights. So it's a hard question. I'm glad we're having this conversation.
Okay, so thank you all very much. And now we just want to open it up and take questions from the audience. I can come around, I'll do my best to come around with a microphone, ask a question, and then panelists, you can decide amongst yourselves who wants to answer it, or if you all want to answer it, you can all sort of pile on. So any questions?
Well, if I could pick up on what you were saying about Title IX, are you all familiar at all with Sigal Ben-Porat's book, Free Speech on Campus? Okay, so she lays out an argument that it goes, and I'm genuinely curious to hear what you say about this, that one of the precedents for potentially limiting certain kinds of speech is the objective harm that it causes minoritized communities on campus, and the degree to which that violates their Title IX right to an equitable education. And so I'm curious, constitutionally, if there is a leg to stand on for those arguments in the courts, what you as experts have to say about that.
Okay, so when it comes down to a conflict between Title IX and the First Amendment should win. I mean, I think that's the big takeaway on that sort of thing. I think it comes down to, when we're talking about speech codes on campus, is what kind of forum are we talking about? Because yes, you can say in certain things, certainly not maybe a public forum, but as I said, in the classroom for sure, the hallways, maybe some of the other non-public spaces. Yeah, I think you can do those sorts of things because you can make reasonable limitations on speech so long as you're not talking about the content and you're not talking about the viewpoint, basically, of what you're doing. And it's especially big if you're talking about the educational mission of the school that's being compromised. But I think the dangerous thing here is when you talk about the idea of, well, but Title IX says this, and how does Title IX intersect with the First Amendment? That is, which one do we prioritize? And the answer is, in the law, you prioritize the First Amendment because that's the way the Constitution works.
Yeah.
That's the way the Constitution works, and you can have all the anti-discrimination laws you want, but the point is, the First Amendment trumps that.
No, I would actually agree legally. That's 100% correct, and I think that's why the Ninth Circuit decision was so interesting. Like, they really wanted to bring Title IX in, and so they're like, okay, it falls within this First Amendment recognized exception. And so I think as we continue to see I don't know, well-meaning judges maybe try to do that. I think it's going to get interesting. I think it's going to make the doctrine a lot more complicated outside of that context for sure.
I think they covered it, so I won't.
Okay.
Well, then this is just a quick follow-up. I think this is more a question of clarification. So what I'm hearing then is, as an instructor, I can put limitations on content in the classroom legally.
Oh, sure.
Okay, just wanted to make sure. Thanks.
It would seem that there are times when the scenario of a queer T-shirt could be fighting words, or the N-word in the cafeteria said by the whites to the blacks would be fighting words. So, that seems a bit of an arbitrary. Where do you go, and do you prove it by having a fight?
Just throwing a punch to make your case, yeah.
So you can make the case.
So the T-shirt, probably not, because the fighting words doctrine tends to say that, unless the person would say, come up to you directly, if you were a member of that community and say, see this, your responsibility in that situation, because you're not a captive audience, is to look away. And so that might be something. And as for the N-words said by a white person, it depends on the context. Depends on who they're saying it to. Is that just a general thing they're saying out there? Are they calling someone that? Because then suddenly you're back into the fighting words doctrine. So it really is it seems arbitrary, and I will say to a certain extent sometimes it is, but it's a fairly limited exception to the ability to express viewpoint.
We have the exception for fighting words now. So if it were interpreted in its use as fighting words, that's something that could be done now without having to have a separate hate speech exception. So you don't need to create the hate speech rules in order to address that. My general thought on this, having been raised Jewish, my father saying, why are people protesting the march in Skokie back in the 70s, just let them do it and go on, no one's going to know about it. The more restrictions you put on speech, we hear about we shouldn't talk about civility, and civility codes have been thrown out by courts when universities have tried to put in civility codes because it chills free speech, because people feel they can't say something. When you start getting into hate speech, and you start getting into regulating hate speech, you start getting into regulating offensive speech, you're going to have the same chilling effect. And people aren't going to know what they can say or not say when truly trying to have just a sincere conversation and express an idea they feel, but someone else could be offended by it, although they may not be aware of it, and so they won't make the statement. And then you've immediately lost the opportunity to have conversation and interaction to figure out whatever it is you may be trying to figure out. And so for that's why I think if we can get it to fighting words, we've already got a way to deal with that. And if it's not fighting words, personally, I think we just need to find better ways to have the conversation and address it other than creating another rule.
I was wondering if it makes any difference if the campus is a public campus like this one at Washburn is, or if it's a private school. And I'm thinking about a situation last year where there was an academic conference at Bethel College in Kansas about Mennonites and the Holocaust, and I was there, and unfortunately that conference attracted a Holocaust denier who came into the conference and was disruptive and was arrested, taken from the premises, and he's now suing the college and people that were part of that conference for the way they responded. Does it matter that Bethel's a private school and not a public institution?
Yes. Now, as far as how they handled it, there may be other legal issues as to how they handled the arrest. As a public entity, so the First Amendment says Congress shall pass no laws. And so that was designed, Congress shall not pass laws that restrict freedom of speech. And then with the 14th Amendment, kind of passed that on down to state and local governments. So public colleges, public institutions like Washburn, KU, Emporia State, we are publics, so we are under that same constitutional restriction. We cannot pass a law. Private entities don't have that same restriction. Getting a little off base here, the San Francisco 49ers could have fired Colin Kaepernick for kneeling because they're not a public entity. So technically, First Amendment doesn't apply to them. So Bethel would have the right to have that rule because they're private. Washburn could not have that rule because we're public.
Okay.
So in terms of protecting the First Amendment rights of students in public universities, it seems some universities, and I'm thinking of Wichita State and Emporia State in two recent cases where they did things that seemed to pretty clearly violate students' First Amendment rights. One with Wichita State was denying a student group a right to create a group. And then in Emporia State, it had to do with impeaching a student senator for something she posted on Facebook. And in both of those cases, the university didn't do anything until the student hired a lawyer or got a public interest lawyer to come and make their case. And as soon as the public interest lawyer made their case, the university switched and just said, okay, well, we won't do what we're going to do. And that kind of puts a burden on students that in order to get their First Amendment rights, they have to be able to financially be able to get a lawyer or be fortunate enough to have a lawyer to do something pro bono for them. So in that environment, if a university doesn't really value the First Amendment and want to protect the First Amendment, how do you get them to do it if they have potentially the strategy to say, well, we'll just do this even though we know it's illegal, but let's see if you hire a lawyer?
I kind of feel the camera's on me on this one. Yeah, I do appreciate that, Paul. Thank you. I'm not familiar, to be quite honest, with either of those instances. You know, all I can tell you is every institution is different. The only thing I can say is there are times in all types of instances in law, not just in this, there are people who understand or are willing to work, and if there's a problem, they want to try and work out the solution and resolve it without having to get to everyone pulling out their lawyer and getting to that point. There are other administration that know, well, as long as we don't feel pressure, we're not going to do anything. And then part of it may be how they interpret it. Okay, so I can't say these things. They may have reasonably interpreted, sincerely interpreted that what they had done was correctly. And maybe it took the attorney to make them aware, no, you really didn't do this, because they didn't see it in a way, for whatever reason. I can't, since I don't know the facts, I can't say. I would hope, and at least since I've been here at Washburn, it's been my sense, and I've worked at another institution, and I'm not necessarily on First Amendment rights, but what I've seen here, there's certainly a commitment to being open and consider and talk and figure things out. That's all we can hope for. We're never always going to agree on everything. But the reality is there isn't. There is there are organizations. I don't know if the ACLU charges or how they do that.
We're free, so donate to us so we can take on more of these cases.
There's ACLU. I don't want to give you all these people to go call and harangue me with letters next week. But there are organizations that are out there specifically to deal with people's constitutional rights. If they feel they're being violated, those organizations are willing to step in without charging them anything. Did you want to?
Oh, yeah, I mean, I can keep plugging for
Yeah,
ACLU donations, but no, I would say that, it's unfortunate that kind of civic outside organizations sometimes have to put pressure on government institutions to do the right thing, but I think that's pretty consistent across the board, unfortunately, and I think it's, a reason why lawyers do have some social value too, so.
Yeah.
So I've been here now for a year and some change, and one or a couple of stories that I have heard circulating amongst students, some faculty, some staff, are instances where the university has, a couple of instances where the university has decided, no, that person's not going to speak on our campus. So the two people that I'm thinking of are Colin Kaepernick and Ben Shapiro. So, and to my understanding, Colin Kaepernick was going to be funded with WSGA money, and he does not have a record of inciting any violence on any college campuses. Ben Shapiro was going to be funded by an outside source, so not with any university-related funds. He does have a history of inciting violence on college campuses. Now, I don't know if either of you can talk about these two examples, like in details, but can you maybe help me try to understand the logic behind saying no to these two particular speakers?
To my knowledge, and I know more about the Shapiro thing than I do the Kaepernick thing. The Shapiro thing, no one ever said no. There were talks. Vice President Grosspitch was speaking with a group where they were trying to work out different kinds of situations and how it was going to work and where it could occur and what were they doing. And then the next thing we heard, he just wasn't on. We weren't on their schedule. So no one at Washburn, to my knowledge, ever said Ben Shapiro could not come to this campus. I have very little knowledge about Colin Kaepernick. I heard he had wanted to come. I heard there was a large amount of money, and I heard that there was a money issue. But again, to my knowledge, I'm not aware that anyone ever said Colin Kaepernick could not come here because of what he wanted to talk about. So as far as that's what I know, and that's what I can tell you.
And I guess I can speak just generally how you could handle that as a university, right? Because in general, universities do have the right to limit speakers who come on campus and use university facilities with the idea that, you know, we're limiting speakers only to, I guess, things that will promote education kind of idea. So they could have certainly said, you know, maybe no speakers on certain topics that we think will be divisive. Now, what they could have also done, but we're not probably required to do, is they could have made a distinction between having Colin Kaepernick on campus and not having Ben Shapiro on campus for the very reasons that you mentioned. That is, you know, a demonstrated history of disruption kind of idea. They could have made that sort of a determination and still complied with the First Amendment because they're not actually targeting the content of the speech, right? They're targeting other things involved. They probably could have justified a determination to invite one but not the other based on that kind of situation. But they're not required to. That is, they're not required to invite all comers to use university facilities to speak. They could have made the decision, but it was okay for them not to, constitutionally speaking. So long as they're not, you know, saying something like, Ben Shapiro, even though you've got a history of violence, we want you to come. And Colin Kaepernick, we don't like what you're going to say, so we don't want you to come.
I have kind of a question piggybacking off of that, because we have a situation, you know, on campus now where we're having a speaker coming on Monday, I believe, who's pretty controversial, and comparisons have been made between this speaker being allowed to come and Kaepernick not. So Curtis Bowers, and you know, with the idea that we're bringing speakers to you know, to advance the pursuit of knowledge and share ideas, when you have a speaker who has a history of making, you know, demonstrably false and misleading claims, it is kind of arguable whether that's really adding to the pursuit of knowledge at the university. But I'm also thinking of speakers who have come to campuses in recent years or announced that they're coming to campuses kind of specifically to be silenced, you know, to make themselves a target so that they can feed a narrative that, you know, of cry bullies silencing conservative perspectives on campuses. And I'm wondering, given some of the, I think, to my mind, really powerful ways that students recently have made their voices heard at Washburn, and still, you know, face those kinds of accusations of, you know, silencing others, being uncivil, etc. How you would advise students to exercise their free speech rights in light of, you know, speakers like the one we're about to have on campus.
Lauren mentioned in the lawsuit sheet the case about the way you go against speech is with more speech. There have been a couple of interesting instances I'm aware of, one more closely and two through others, that have been real good examples of that. And that's why I've been to a couple of conferences with college and university attorneys. And there's been plenty of places where Milo Yiannopoulos and Ben Shapiro have spoken, and there weren't any problems. And in most of those institutions, they worked with the students when they came in, they set it up, and they also, there was opportunities for people in another location to speak out against kind of a counter-protest or whatever you would like to call it. And everything went along dreamily, no one even knows about it. Everyone thinks they get shut down everywhere, and the reality is most of the places they go speak, it's not a problem. There are three things I think about that's a wonderful example of alternate speech. One was, my understanding was, kind of came up an idea by a high school kid, I think in the Shawnee Mission area, when the Westboro Baptist Church went to speak at a high school or a school. And I know personally in St. Louis, they did a similar thing when I lived there, when someone came and spoke at a middle school in Clayton. They decided to create a fundraiser. And what they did is they said, we're going to do a fundraiser. We ask people to pledge for every minute that the person from the Westboro Baptist Church speaks, you will pledge however much you want to pledge, and all that money will go to the LGBTQ student group at this school. And they held up a sign. They kept track of the pledges and the number of minutes and the amount of money that was being raised. I don't know how it worked in Kansas City, but they used that in St. Louis, and the person voluntarily on their own walked off after 7 minutes as the numbers. No one shouted him down, no one did a heckler's protest, just stopped and left. A wonderful way of counter speech. When I worked at St. Louis Community College, we had some folks handing out Bibles. And they would talk about how homosexuality was a sin, and they were saying things and people were upset. And they went to our police and said, what can you do? You know, it's First Amendment, we can't do anything. So on the other side of the small quad, someone stood up and he started talking about all the things that people from the LGBTQ plus community had done on the campus, in the St. Louis area, nationally. And people started gathering around, they started cheering and yelling out more things. And pretty soon that crowd was so large and so loud, no one even knew the Bible folks were there, and they just packed up and left. No one even knew that they had left, because no one was even paying attention to them. The third one, which I've just always enjoyed the most, happened, I believe, at the University of Illinois. There was a conservative student group that wanted to show why they believed that the welfare program was just gave things away to minorities and made whites have to pay for everything, and why they didn't like it. And so they had a welfare bake sale, where if you were a person of color, you could come up and you could just get a brownie. You didn't have to pay for it. If you were white, you had to pay $2 because you had to subsidize just giving food away to the minority. And people complained. Well, that's discriminatory. And the university said we can't do anything. Down the walkway, set up another table covered with packages of popcorn. And the sign was white privilege popcorn. If you walked by that table, someone went and just handed you the popcorn. You didn't have to come up and ask for it. You didn't even have to look at it. You just got it because you were there and you were white. And if you weren't white, it didn't matter how much you wanted it, you didn't get it. And the bake sale went away. In all three of those instances, ideas by students standing up, using speech in a proper way to counteract without being a heckler's veto, without inciting violence in any way, shape, or form, But using speech stopped the bad speech, and so good speech did overcome bad speech. And that's why I've always believed, I believe that idea, and that's why I think it can be done with the right processes, and we don't have to worry about protesting. The good speech will win out if done appropriately.
So I just want to say I 100% agree with that, but I'm a civil rights lawyer. I'm going to be a devil's advocate for here. I just think that we have to really examine what we mean by beat out that speech. I mean, I think we're really starting to understand the trauma that people of color, the LGBTQ people experience when they're subjected to hate speech. And so it might have been like a good overall feeling for everybody, but I think we also have to ask what happened when the people that were being targeted by the speech went home, and kind of whether that really remedied the problem for them as individuals. I completely agree with you that those are all fabulous examples, and that's precisely how I would tell anyone to protest. But I think that's kind of where we're starting to have these hard internal conversations with the ACLU is now that we're becoming more aware of the impacts of hate speech on people, kind of whether the remedy actually happens.
Well, and I think that's a great point. But again, I think if we create a ban on hate speech and we were to punish those people, we still deal with that problem because those people will still go home. So what we do is we find ways to counteract the speech itself. And then what we have to do, and I think Washburn, I don't know because I'm not involved with that stuff, I know they've worked at it, how well we've done so far, but they've tried to work to find other resources to work with folks to find other ways to help deal with those other feelings and try and find ways to help them work through that. I don't know how good we're doing because I don't follow up on that, but there's discussion about having those resources, and that may be one of those areas that we're talking about that we need to find more and better ways to do things to have more of those resources available. But again, that won't stop hate speech. That's finding a way to accommodate what happens when the hate speech occurs and how can we help people work through it, because we're not going to be able to stop it. So what are alternative ways of helping people address it so they can still continue to come to class, come to campus, be involved, and not allow that incident to affect them? We've been cutting you out.
Totally okay. And I tend to agree with what you say there. And I just want to mention, there is a First Amendment background here. And on college campuses, there is this idea, and the Supreme Court said it in Healy, this idea that the bulk of campus is generally regarded as a place where you have the free exchange of ideas. And there is a kind of, I guess, traditional presumption in that sort of situation that you will exchange ideas. And you may not like many of the ideas that are exchanged, but that is kind of the purpose of a university setting. And part of that is the background that animates the First Amendment. And so you have a situation where that's kind of the baseline idea for what we think of as the First Amendment, and that limits really what universities can do in many of these situations.
Lauren, can you say more about how this conversation is playing out internally within the ACLU, and what are some of the other proposed solutions for going forward? Yeah,
so I mean, I can say, not too much internally, but I think most of our internal conversations have had some kind of, external view at this point. People are starting to hear about these conversations. We've been open about them because we're a transparent organization. But I don't think there's concrete proposals yet. I think there's just more conversation, and as there's more millennials working in the organization and supporting the organization, I just think that we're having these, we're having to talk about it. And I think pure civil libertarians who've worked at the organization for a long time are having to get a response to what you just said, that universities used to exclude black people and brown people too, and that's their history. And we have to have those conversations, and And they're really hard, but I mean, I think that they're good, and I think we'll be a better organization because we have them. And I think we are going to figure out how we can, you know, resonate these two rights and all these values that we hold really dearly. So.
I know we're short on time, but maybe one more question if anybody has one.
Do you want to talk more about the heckler's veto? Because a lot of times the violence, especially with the Ben Shapiro case, I think most of the publicized violence was not from people who were coming to hear him talk, but people who were coming to protest him talking. And then other cases like the Middlebury case, where the violence is not from the people who are trying to speak, but by the people who are coming to protest to speak. So how do you balance the heckler veto and limiting violence on campus?
It's not good. I don't know if you want to talk about Charlottesville. I don't know if you want to get into that.
Yeah.
It's kind of like that.
Yeah,
But I don't want to put you on the spot.
I mean, yeah, go ahead.
Well, I'm not a real expert on the heckler's veto, so I don't want to claim to know too much, but there's that, there's that question. I mean, it's interesting because there's been some recent cases where there's been protests in classrooms in the last year and a half. There was an ICE official that spoke at a school, was invited. The class students voted to have him speak to explain immigration policy because they wanted to know that. And people came inside the room or were standing right outside the room to the point where he couldn't speak and they had to escort him out. I'm kind of wondering, because as Jeff said, there's the right to have some control over what goes on in a classroom. But in a more public setting, when does everyone has a right to speak? So when does it become so disruptive that the First Amendment would allow you to take action because of the disruptive nature? And I'm not the expert on that. Fortunately, I've not had to deal with the heckler's veto, so I haven't spent a lot of time looking on that. But if either of my colleagues up here on the panel have dealt with that more directly, that's where the issue is. When does the heckler, when do the courts recognize that goes beyond First Amendment rights, become so disruptive that now crosses the line from First Amendment protections? And I don't know that, but that to me is where we get the issue.
Well, right, and there's a strong tradition in First Amendment that we don't have a heckler's veto. That is, we don't want situations where government is reacting because of the response to what is being said. And we see a lot of the idea of these heckler's veto cases. There were lots of times when, during the Civil Rights era, this idea was used, we don't want African Americans protesting here. Why? Well, it's going to be a disruption because of what we're going to do, right? Because of what really non-African Americans were going to react to that. It was, I'm sorry, you can't march here because we think the community is going to be upset. That was the whole Skokie thing too, right? It was you can't, we're not going to let you march here. We're not going to let you present your viewpoint because people might take offense to it and they're going to run into problems. And it's a struggle in the First Amendment. I mean, there's probably a place where all of that, becomes a big issue. But I think the First Amendment would say, well, target the problem, not the person who just because they're speaking is the one that you see as causing the problem.
Oh, yeah, no, I would just agree. I mean, I think it's very fact-based, and I think these are hard cases. Sometimes when you're trying to draw the line between what's a, heckler's veto, what's a reasonable, response, yeah. So I don't know. I'd have to have a specific example, so thanks.
Okay, thank you very much to our panelists.